Didn't anybody ever tell you how a courtroom works? Okay, in the criminal justice system, the people are represented by two separate yet equally important groups.
Dude, we've seen all the Law and Orders.
Oh, me too.
You're charged with no insurance, the same as the last two defendants, and improper registration plea. You haven't restored the insurance or the plate, so the prosecutor has a different plea offer in your matter. Ms. Davis, if I understand it here, the offer is to plead to allowing another to violate the motor vehicle code and dismiss the other charges.
Yes, Your Honor.
It's an interesting plea offer. It is a generous one. They're going to dismiss the no plates, which is to save you $120. And they're going to dismiss the no insurance, which is going to reduce your fine by several $100s. But the misdemeanor charge of allowing another to violate the motor vehicle code is the plea offer. The others were a civil infraction. This is a misdemeanor, a very minor one. It's punishable by up to 90 days in jail and a fine of up to $100. It carries no points, and it doesn't go abstracted on your driver's license. Do you understand?
So it's just like a fine that I would have to pay?
Yes, I'm going to give you a fine, and I'll give you some time to pay it.
Okay.
Other than that, did anyone promise you anything?
No.
Or threaten you?
No.
And as you told me, you were driving to school.
Hey everybody, I'm gonna go ahead and jump in. We got some good storms here tonight, so I don't know how long my internet's gonna last. I got a lot of fun cases for you since I haven't been live in so long. Thank you guys all for coming out. Happy Father's Day to all the fathers out there. Someone said I'm supposed to say Happy Father's Day to all the mothers out there, but I think y'all had y'all's last month, so we'll do the fathers tonight. Thank you guys for coming out. We're gonna do some Judge Middleton. We even got some old Squishy Gardner clips and Miss Fields clips. So let's see if we can get up.
School to pick up your daughter or
It
drop
was
her off.
later in the afternoon. My neighbor's daughter was babysitting my youngest, and they had went on a walk when it was still sunlight out and walked up to her mom's work, and her mom didn't want them walking back on the highway at nighttime.
Well, you
I
weren't driving
didn't
to
really want
school.
her
This was
walking with my
10:43
2-year-old.
at night.
Huh?
This was 10:43 at night.
Yep.
Doesn't have anything to do with school. I'm sorry. 131 of Dickinson Road. Where were you going?
I live in the trailer park in Constantine. I
Yes.
just got back with my grandparents from dropping off my two oldest and three Herbers. And then he left, and I was taking a shower before I went over to my neighbor's to grab my youngest. And when I went over there, she wasn't there. They had apparently went on a walk, and they didn't want to come back on the highway alone. I didn't want them coming back on the highway alone that late.
How long's your youngest?
So-
Youngest?
My youngest is 2 years old.
They're walking around at 10 o'clock at night with a
No,
2-year-old?
I have a big wagon. It's like a stroller wagon. So they put that up. It's got a big canopy on it, and
Where did they walk to?
McDonald's right there in White Pigeon. That's where her mom works.
They walked from the trailer park to White Pigeon?
Yeah.
You need a new babysitter.
She goes on walks a lot. I have two big dogs. They have two big dogs, and she'll come over and just take my dogs on walks all the time. Sometimes my daughter will trail along with her if they're going like down the trails in the woods. But they like to hike, so she gets it from her mom.
Well, I'm not gonna even go down that road. All right. Plus, you told me you were going to pick your daughter up at school. This is all pretty bogus. Your license is.
I wasn't saying I was picking her up from school. I was just saying that from what I understood on the restricted license, I was still able to pick my kids up. And
Not
I
for
thought it
this,
said
not
like
for this.
kids up from daycare, from school, stuff like that.
No, you can't. You can't pick your kids up from daycare or school. Let me go through it again. So that's outside of your restrictions.
Okay.
may drive to and from your residence and place of employment, treatment, support group meetings, regularly scheduled treatment for medical conditions, probation, community service, and your school must carry proof of destination and hours. Shall not drive a vehicle requiring a commercial driver's license. This is a very generous offer, and you should be grateful to the prosecutor for it. It's $100 fine,
I am.
$125 of state costs for a total of $225. Now, paying the fine will give you less money to reinstate your car insurance, but can you pay that within 30 days?
I should be able to, or at least start with making payments, get something
Alright.
set up with them. But I should be able to pay it all off by then.
All right. Who brought you here today?
I drove here.
That's outside your restrictions also, but I guess it's court. But that's not within your restrictions either. So drive home and stay home.
Okay.
Don't let your kids go walk around at 10:30 at night in the dark. That's all spooky on a school night. All right. You're good to go.
Thank you.
All right, Mr. Wilson's going to take a little bit to unpack here. Antonio Wilson, would you come up? Laura, would you bring me the pretrial? Do you have the pretrial files on Mr. Wilson?
We do have.
All right. Can I see those? Mr. Wilson is set for arraignment today, and he's set for some pretrials today. Prosecutor Davis is here with their intern, Ms. Stoll, and we'll see if we can sort all this out. Two five one oh one. I don't want to start with that one. 25807 and 808. He got a ticket on April 30th for driving without insurance and no valid operator's license and failed to yield to an emergency vehicle. You had a pretrial, or you had a case earlier, you didn't show up. So I tried to reset everything for the same day. So that was on April 30th. Let me look at that ticket. M60 and Fulton Road in Leonidas at 10:15 in the morning on April 30th, which was a Wednesday. No insurance, driving without a license, and failing to yield to an emergency vehicle. The insurance, as you heard, is a misdemeanor, punishable by up to a year in jail and a fine of up to $500, not less than $200. Then you got another ticket in file 251017. On June 2nd at 11:15 at night, US 131 and Broadway. Driving at 2008 out. So that was set for one day, I don't know what. So that's a no operator's license is a misdemeanor punishable by up to 90 days in jail and a fine of up to $100. Let's go back a little farther. You got a ticket on April 7th for driving with no insurance, no valid license, and going 95 in a 55-mile-per-hour zone. So you got a ticket on April 7th for driving without a valid license, no insurance, and driving back to the future. 3 days later, you get the exact same ticket. Excuse me. 23 days later. No insurance, no ops, failed to yield for an emergency vehicle. Plus there's some civil infraction stuff in there. Then you still don't care. On June 2nd, you drive some more and get another no ops ticket and you drove to court. There is jail in your future, Mr. Wilson. My suggestion is that I get an attorney to help you with this and set this for further pretrial. Ms. Davis, there's a lot going on here. You're probably not in a position to make a plea offer that would resolve all of these at this time.
No, Your Honor. I guess if the court and Mr. Stigley to inquire as to work, that sort of thing, I'm inclined to ask for the court to take him into custody and start serving time now. It's frustrating.
It
when
is
we
frustrating,
get
and
all of
I've
these
done it.
tickets. And 95 miles an hour, I looked
Yes.
up where that ticket was. It was Lutz and Woodside, which is near Sauganash Golf Course. That is a very dangerous area that goes up and down, and there's the railroad tracks there. It is absurd that he would be driving that fast down Lutz Road.
Yes, the problem is I didn't see him drive. The bailiffs did, and he's not charged with anything. At one time, I was lodging people for these. I'm not sure I actually had authority to do that. He doesn't seem to be taking things very seriously.
Yeah.
But I think he could. So now, you've come to the attention of the head prosecutor. So she knows who you are. She knows what you're doing, and they're going to pay attention to this case and probably advocate for a jail sentence because you don't seem to be taking things very seriously. Are you working somewhere?
Yeah.
Where do you work?
Well, I start work Monday.
Where's that?
The gas station.
Which one?
It's like out there by Jones.
I'm not sure.
So the judge asked him, "Do you work?" Yes. Where do you work? Well, I'm about to start work at the gas station. Which gas station? I don't know, the one in town. And he wonders why he drives to court in front of everybody.
I would believe that. But
Omar?
you live on
When
A.L.
you
Jones
work-
Road? Is that true?
Mhm.
All right, I don't know what you were doing in Leonidas and Three Rivers and the other driving so fast. I bet if I called Johnny's gas station, they would say they didn't know who you were,
It's
but
a Lightning Quick, which I think is the one that would be just east of that. The north side of
the other,
road.
the little one?
Is that
Mhm.
Okay. All right, anyway, I'm gonna appoint an attorney. Show a plea not guilty.
You can make arrangements to have somebody pick them up, Your Honor.
Yes. Appoint an attorney and set attorney pretrial for July 11. We're gonna be very busy that day. Give you a heads up, Deborah. So if you want the prosecutor to get what they want, you drive home from here and you'll get picked up on the way there and they'll impound your car and take you to jail. You need to start to take this seriously. You've hit rock bottom and continue to dig deeper still. Let's talk about your driving record and why you're in the position you're in. Your license is expired. Gee whiz. So you were actually eligible to get your license back. And then you keep doing this. Did you ever go to SOS to get your license back?
No, I only got a far as a permit.
Well, I would suggest that you go to the Secretary of State, find out what you need to do to get your license. There really isn't that much baggage on here, but you're heaping it on here. I don't know why in the world you'd be going 95 miles an hour in that location.
Passing a vehicle.
Yeah, at the time I was passing two
You
vehicles.
probably should
Oh,
have done.
boy. That makes it even worse. It's not straight and flat. It's straight if you look at it on a
I
map.
wasn't by the golf course spot.
All right, well, you're by Woodside Drive, which is still very hilly south of there. At any rate, stop doing what you're doing before you get so deep in the hole you can't get out. So
Or you can-
3 suggestions. I want you to go out to the counter and they'll give you the paperwork regarding your attorney's name and number on it. You got 3 separate incidents of driving with no insurance and no license. April 7th, April 30th, and June 2nd. And today is June 12th, and you drove here to court. Who owns this Audi?
Me.
I will park it till you get licensed and insured.
Oh, I have insurance now on it.
How do you get insurance without a license?
My mom's.
All right. That might help. So I want you to go to the Secretary of State. You need to make an appointment. You can do it online, go in there and talk to them. Say, what do I need to do to renew my driver's license? Then I want you to call your lawyer and make an appointment to discuss this case with them prior to July 11th. And I want you also to show your lawyer that you have current insurance on the car. And then I want you to call somebody to come get you, or your car's gonna get impounded and you're gonna go to jail, and then it's really gonna be even worse. So even though I wouldn't mind locking you up, I don't know that I have the authority to do that because I didn't see you do anything. But don't do it. So you go out to the counter, get the paperwork with your lawyer's name and number on it. I want you to call them and discuss this. I want you to make an appointment with the Secretary of State to find out about getting your valid license. All right, you're good to go. And then call somebody to come get you.
All right, I'm going to jump around a little bit. I messed up on the recording, so I had to do it again. So we're going to jump over to Judge Stevens. I think this one's, I'm almost certain. Yeah, I'm almost certain this one's an old Squishy Gardner one. He put some good detail on his, so we'll be able to tell pretty quick.
He's been convicted of arson and was sentenced to 20 years in prison for arson. An aggravated assault, sent to 8 years in prison in that case. That was before this one.
And Your Honor, I have one witness besides Mr.
Yeah, I'll put money to this old Squishy Gardner. Make sure to go check out old Squishy Gardner's channel. He's got a good channel. I think everybody's subscribed to him already, but make sure to go show it some love. Thank you.
Noble. That's your, okay, that's President side there, right?
This is clause number 39549.
Yes.
This one.
Yes.
And then there's still 37734.
Yes, I would like to keep it.
All right, it's called State of Texas versus Jason Gregory Noble.
Your Honor, should I bring everything in the way?
If I remember correctly, Judge, there was a pleas true as to the
All of them.
ours. So his exposure is 25 to life.
It was a second degree felony just on paragraph 1.
Yes, sir.
And then he pleaded true to paragraphs 2 and 3. What does that make it, a habitual felon?
Yes, sir.
Okay, 25.
Yes, sir.
All right. Pre-sentence report has been tendered to the parties. Any objections or changes to it from the defense
Mayor,
or state?
No, sir.
Okay. The agreement is, again, the courts, it's open to the court for sentencing under the punishment range that is applicable under these circumstances. So what says the defense?
Your Honor, I would ask the court to take into consideration that although there is an extensive history of assaultive type cases and offenses involving violence, I would ask the court to take into consideration that Mr. Noble was introduced to violence at a very young age, 13 years old to be exact, by his father, when he was at a critical developmental age in his life, and began with assaultive offenses as a juvenile as young as the 11th grade. And it's kind of continued on since then. And Mr. Noble has not received any kind of treatment for his anger and his aggression ever. And
How old is he now? How old is he?
51. He's 51.
Whose fault is that?
Now, I'm not saying that it's anybody's fault.
Oh,
I'm just
okay.
pointing
Well,
out
we
the
wanna know
fact
that-
that he has not received any kind of psychiatric treatment or counseling or any help to manage his anger
Oh,
issues. And
so
on
it's nobody
top of
else's
that-
fault.
Yes, sir. And on top of that, he also has been diagnosed as being bipolar. And he admits that he was prescribed medication, but he stopped the medication. And I would like to point out that there's never been any kind of medication management or oversight, and that may have contributed to some of the anger issues and his overreaction in the present case.
You're cryptic. What does that mean?
Which part?
There's no oversight, and what does that mean?
Well, meaning that he didn't have any help with,
When you're prescribed
shopping.
medicine, when you're at home, you take medicine as prescribed. We all do. The doctor doesn't come in and says, okay, I'm going to watch you in video to make sure you do it. We're grown-ups. You're prescribed medicine. You can either take it or not take it. It's free will.
sure.
And if you don't, then if something bad happens because of that, then whose fault is that?
Well, Your Honor, I'd like to point out, in Officer Riley's report, that because he was not receiving mental health treatment and going to regular counseling sessions and getting, that they could not ensure that he was receiving this medication.
Why not?
Well, because it's just never been ordered in any of the times that he's
Wait,
ever
wait.
been on probation.
No, hold on. He's not going to regularly schedule doctor appointments? That's what you just said. Whose fault is that?
Treatment.
Okay, okay. Well, who ordered the treatment?
Well,
Was it recommended by a doctor? But you didn't go.
I was traveling in town.
What, that's your, whose fault? Okay.
okay. There's also been an extensive problem, extensive history with substance abuse. And I'd like to point out that Mr. Noble has never received any kind of treatment or rehabilitation or therapy relating to his substance abuse issues. He did report that he was going randomly to NA and AA. But the last one was in 2018. So taking all of these things into consideration, I would ask the court when it discusses the sentence that it show leniency. Mr. Noble, on the date of this offense or the date that this offense occurred, he truly believed that what he did by trying to disarm Mr. Knighton with a weapon, that he was saving his life and his mother's life. Based on the fact that, according to Mr. Noble, as it came out in court during the trial, Mr. Knighton had discharged the gun prior to that evening when he was high on methamphetamine. Or methamphetamines. And so, Your Honor, even though he did overreact, the injuries were severe, but he truly thought that he was doing what was necessary to get the gun away from Mr. Knighton. And in the supplemental PSI report, Mr. Knighton himself states that he has forgiven Mr. Noble, that he actually resided with him when he was out on bond after the current offense. They've set aside their differences. They call each other, Mr. Knighton and his mother have continuously contacted him and spoken to him on a regular basis. And although they did not appear, and I'm not making excuses for them, but they really did not want this case to go forward. And unfortunately,
Why do you think?
well, because he didn't think that he should serve any more time, that he's already served time, and that's according to what's in the PSI report. It's time served. That's what it should be. So the victim himself is telling the court and everybody that he comes into contact with, in addition to signing 2 non-prosecution affidavits, which, never came out because they didn't appear. He didn't appear in court. He has consistently held the position that he did not want Mr. Noble to be punished for this. And why would a person do that? It's not because he was scared of him.
I'm sorry, the victim, as we recall,
Yes.
had the gun, the barrel of the gun imprinted on his forehead.
That is correct, Your Honor. I mean,
Gee.
and I'm not
Well, what do you-
downplaying the injuries.
What do you think could be reasons? Maybe a victim like that. This court has never seen such a thing. Never seen. Somebody had to jam a hot metal. The gun had been fired in just a few seconds, stuck up against the forehead and burned into the man's forehead. The barrel of the firearm. How ruthless is such a thing? How ruthless? They had to think the next moment the trigger will be pulled and there's no escaping it. A bullet goes through your brain.
Well, Your Honor, I'd like to point out that at the time that the gun was used to hit Mr. Knight in the forehead, the chamber or the magazine had already been expelled and the bullet in the chamber
Once
had been
again,
ejected. And then that's
you-
according to his own testimony, and it was found in his pocket. Mr. Knight.
So play down the fact that he puts a burning hot piece of metal in the man's forehead. Play that down, would you please? That is as mean-spirited as it gets. What? Okay. Oh, so was he doing it for fun? No, he was doing it to hurt the man. It was just an act of meanness.
Your Honor,
You
can
were-
I call
you-
Mr. Noble? He would like to address the court, if you would give him the opportunity.
Yeah,
Mr. Noble.
that's you?
Yes, sir.
Raise your right hand. You solemnly swear or affirm testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Lower your weapons. Go ahead.
I just want to apologize, Jill Stevenson, for wasting your time, that works time. I did not want to go to trial in this case. I was in Mr. Anders made an offer to me. My stepfather, he comes to see me regular up here in Jefferson County, been here 2 years. And I told him that the offer was 20 years. And they told me, do not sign for 20 years. If you know, they just didn't believe that the offer was for 20. We had forgiven each other about the altercation, but if he was just saying just a few seconds ago about the pistol and everything, my stepdad did fire a firearm previously about 2 weeks prior to this inside the house, and it really scared me, scared my mother, and there's a lot of other episodes.
So it's his fault.
No, sir, it's not his
The
fault.
jury found otherwise, you know that.
Yes, sir. I'm gonna respect the jury's decision too.
All right, let's respect the jury's
Yes,
decision,
sir.
finding you guilty of aggravated assault, family violence.
Yes, sir. And there's no excuse for me acting like that, behavior like that. There's no, I don't understand that. But I guess I overreacted in the heat of the moment.
Which time?
What happened?
What about your prior convictions, which are crimes of violence? Let's see, arson,
Yes, sir.
and what, after that, aggravated assault, another aggravated assault. You were convicted of that in 2010. How many violent crimes do you get before you're held accountable?
Yes, sir.
And I'm looking at your criminal history.
Right.
How many convictions do you have?
She said I had several misdemeanors.
No one should know more intimately about their actions than themselves. How many convictions do you have?
Not 3 felonies, prior convictions on like she's 20 to 30 misdemeanors.
You see anything wrong about
Yes,
that?
sir, very wrong. Very.
After all of those, now you're here before the court for another crime of violence. After 20 some odd convictions. We all see a consistency that should have been dealt with 25 convictions ago. You should have learned a lesson. Okay.
I'd like to call Philip Jones, who is a childhood friend and boss / coworker of Mr. Noble.
Come on up. Where that person is, that's who that is.
Yes.
Okay, what is your full name, sir?
Yes, Philip James Jones.
Raise your right hand. Do you solemnly swear or affirm the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. Lower up.
Yeah,
No, this question and answer.
okay, all right.
Go ahead.
Mr. Jones, your name is Philip Jones, is that correct?
Yes, ma'am.
And how long have you known Mr. Noble?
Since he was probably 12, 13 years old.
And
How long?
12 years old.
since Mr. Noble was
I'm
12 years old?
I'm a little older than him.
You were childhood friends? And did Mr. Noble work for you at one point in time?
Yes, ma'am.
And what did he do?
He was a foreman, supervisor,
And what type of job was this?
scouting.
Okay. Now, did you ever witness any violence in Mr. Noble's household when he was younger?
Yes.
Could you describe that?
Well, I can tell you, like, when we were kids, we were going to fight it out. We'd go to fight it out in the backyard. And if we did something wrong, we would get a whipping. When he was a kid, he would get beat up by his dad, with his fists. And, so.
Okay,
Oh, well.
be there. When you say he was beaten up by his dad with his fists,
Yeah.
can you be a little more specific? Like where his dad punched Mr. Noble?
Yeah, his dad he would just basically take him and beat him, punch him with his fists in the face, in the back, wherever he turned. And then he would get away in the neighborhood and we'd go like,
Okay, now, Mr. Noble's father committed suicide when his father was 45 years old, is that right?
right.
And how old would Mr. Noble have been?
He was probably, well, he was in prison when that happened.
Okay, so he was an adult,
He was in the dog, yes.
okay.
27.
Correct.
Thank you. Okay. Is
No,
there,
so wait, hold on. Your father died at 2001 at the age of 45 by suicide. So at this stage, I'm sorry, you were born in 74.
Yes, sir.
So that's 27 years.
I thought it was 25. I thought it was
Here's
25.
your
Oh, yeah.
I should know more about this than you do. Go ahead.
Is there anything that you would like the court to know? Well, let me ask you this. Did you ever know Mr. Knighton, the complaining victim in this case, to use drugs?
Yes.
And how do you know that he used drugs?
I know that he used drugs. He had my nephew and his Jason's son do up drugs when they was a kid. And so that's back when Logan and Caleb were young. Logan got into some trouble with Kim, and they were shooting up. He was shooting them up with cocaine, not cocaine. I think it was crystal meth at the time.
How do you know that?
I don't know that. Logan is my nephew.
Okay, and
And Logan's mother is the one, you know, that actually that made them get away from there because of what was happening with them doing drugs at Jason's mom's house.
Well, what did the adults do about telling the authorities so that someone could be held responsible?
No,
You don't really know. You were a kid.
Well, no, I wasn't a kid. Logan is my nephew. This Logan is.
I'm talking about when you were watching him.
No, he was in prison when this happened.
Okay.
When Kim was doing drugs
Okay.
with Jason's son.
Okay, so what adult figure needed to talk to authorities to, that's a
That would have
crime.
been Logan. That would have been Logan's mother. Yes,
But other people knew about it, right?
yes, a lot of people knew about it.
But nobody-
I don't know that they filed any charges on him for that. No, I did not.
now the night of the incident, were you contacted by,
Jason's mother.
and Jason's mother is,
Yeah. That's his mom.
okay, so this is night.
Yeah, that's Mrs. Knight. Mrs. Yarland. Yeah, I don't know her first name. Miss Noel.
She had your phone number
Yes,
and she contacted you.
right.
And what was she wanting you to come over for?
She was wanting me to come over to calm Jason down
Okay, go ahead.
because Kim had fired off a gun and then Jason tried to take it from her and hit him with the gun and that.
So did she tell you that, Kim had fired a gun? And that Jason,
Objection, that's a hearsay response.
Sustained.
present sense impression exception, Your Honor.
Overruled, overruled. It's hearsay. There's no way that this can be tested by cross-examination.
Your Honor, if I
I made
may,
my ruling. Thank you. Move on.
no further questions, I'll pass the witness.
Anything from the staff?
I have no question to this witness.
If you wanted to add, sir?
Yes, sir.
Go ahead.
I've known Jason all his life. He has, you know, had a little rough life. He's always done anything for me, and he's always, and the whole time that I've known him, he'd give me a shirt off his back. He'd give any one of his friends a shirt off his back, and he would protect you like you were his father. If you would, just like he would have protected his mom that night, he would protect you. I can tell you, he stayed with me for almost a year and a half after he got out when I bonded him out. My grandkids love him. They miss him to this day. He's a good person. He needs some help with his anger issues. He's never gotten to deal with that. But I can tell you, he's a good person. He don't deserve to go through the rest of his life.
Wouldn't you agree that a person really is judged by the decisions they make?
Yes, sir. And I can tell you, my mom was murdered by her husband, beaten to death. And I wish I'd have been there today to take that from him and kill him instead of him killing him.
Oh, I understand. Self-defense is
Yeah.
under the law.
So you have to.
But the
also
defendant,
take-
I'm looking at, the defendant has been convicted. He's been convicted of arson and was sentenced to 20 years in prison for arson. An aggravated assault, sent to 8 years in prison in that case. That was before this one. All right, then we're talking about he was convicted of terroristic threat, harassment, family harassment, convicted in misdemeanor court, sentenced to jail in those, assault, family violence, assault, terroristic threat, assault, family violence, all those were convictions. Don't you think that this is a consistency of bad choices? We're talking about violence, crimes of violence. How many mistakes do you get to make before you realize, this isn't the right choice to make? It's a tough.
I totally understand that.
I know.
And I know about a lot of those cases, especially the one with Carl Kruger that.
I don't know. I don't know who people are involved in this. I'm just looking at his convictions
And,
which stretch back to 90,
And I mean,
the 1992.
and what I'm asking, can you give him a little help? You know what I mean?
Well, first of all, the help needs to begin with the person who's been making a mistake for 33 years. 33 years as an adult. I mean, it's like you and I, we're all judged by the choices we make. And when we put our hand on the stove, it burns us. We go, well, we're not going to do that again.
Well, I mean, I'm not asking you to make him a better person. I'm asking you to give him a chance to put him in a type of program that can get him to a better person instead of going to.
What are you suggesting is going to change his demeanor?
What I'm suggesting is going to.
What do you suggest?
I suggest counseling with.
What kind of counseling?
Mental counseling.
What is wrong with him that you are aware of medically?
Yeah. What am I aware of is medically that he don't take his bipolar medicine. The only reason he couldn't take it whenever he was at my house because he was in between jobs and so I can tell you as a standpoint, if you don't have the money, how can you take the medicine? You know what I mean? And then if you go in and off on that's a whole other way out of my belief.
Okay.
But I can tell you that working through your mental problems with some type of counseling is better than going and fighting.
I understand, sir. I understand,
You know what I mean?
but I don't know why things weren't done 33 years ago.
Yes, sir.
And here we are.
I can attest to that.
Here we are, and we're cleaning up messes from 33 years ago that adults should have handled a long time, responsible. Oh, I don't know. It's frustrating for us all.
Yes,
I
sir.
mean,
Especially when you love them first.
all right. Is this man
That they don't.
really excused? Is this man excused?
Yes.
Okay, thank you, sir.
Thank you.
Who's next? Who's next?
That is all I want.
Okay. Go ahead. Estate, did you have anything you want to add? What's everybody arguing for here on,
25 years.
is there anything else you want to add?
No, you're.
Judge, I appreciate Mr. Noble's friend showing up and speaking for him. However, the truth is that he was interviewed by law enforcement, never offered any of the comments that he made today about who said what, when, and where. All that's just another great example about how Mr. Noble has done everything he can to try to manipulate the system. Let's start with his victim in this case. He did come to my office and he did give me a affidavit of non-prosecution.
You're talking about.
I'm talking about Mr. Knighton. And as is my practice, whenever someone comes to the office with an attempt to try to drop charges, I visit with them. And one of the first things that I ask them is, did these accusations occur? That's routinely what I do every time. And Mr. Knighton said, yes, it happened. I have to have some peace at home. The only reason why I'm doing this is because my wife's making me do it.
object to the hearsay, Your Honor.
Okay, sustain.
So the reality is, after his state confirmed that the accusations were true from Mr. Knighton, so that's why I proceeded forward. He was represented by different counsel. They went through other efforts. They actually brought Mr. Knighton in. They got him to do a different affidavit saying that those things didn't occur. But the facts are what the facts are, and that's what was presented to the jury. These arguments that he makes today about trying to disarm them and discharging them, that he allegedly overreacted, all those arguments were presented to a jury and were found lacking. They found him guilty. And what we see here today is just another situation where Mr. Noble does not accept responsibility for his conduct. Even his counsel's argument starts out blaming his father, which you heard from Mr. Jones about his upbringing, that he's never had any treatment, that he's made his own decisions about whether or not he's going to take his medication. The reality is that he committed this offense, Your Honor. I'm happy to note, recalls all the details about the pure meanness of this particular act, that a gun that was fired was then jammed into the victim's forehead. The only way we could have gotten those injuries is if it was hot from that shooting. You'll recall that the man was sitting in his chair and there were bullet holes by where he was sitting, all fitting what he told officers on scene. Those
Object, that's incorrect. That's a mischaracterization of the evidence. There was only one bullet hole that was found, and that was by the forensic analysis or analyst that testified.
there were 2 bullet holes. The argument was whether or not there were 2 or 3 bullet holes, and the record will speak about that. So the end result is, again, he's just not accepting responsibility. If we're going to give somebody leniency, if we're going to give them a break, we look to determine what's their conduct. This man was out on bond on a stalking charge. I'm not going to address whether or not those charges are true or not. What I want to address is the fact that he was indicted, he posted bond, and what did he do? By his own admissions in this PSI, he continued to use methamphetamine all the way up until 2023 when he went into jail. That does not comport with your bond conditions, nor does it's meth is against the law. It's continuing breaking of the law. So if we're looking for leniency, wouldn't somebody's conduct be different? His own records indicate that this man is a menace to society. He has excuse me, let me count, Judge. He has 8 misdemeanor convictions. Of those misdemeanor convictions, 2 of them were given an opportunity to do probation, which were revoked. In addition to that, he's got 2 felony convictions, all of which I was prepared to prove up to a jury because I did not know they were going to you until the morning of jury selection. Both of those priors, he did not admit to the offense. He was found guilty by juries in each one of those scenarios. And those sentences that are reflected there is what a jury decided. For some reason, he made the option to switch over and allow you to make the decision. It's 25 to life. It just goes to how this man has manipulated the system. We issued writs of attachment for the Knightons to bring them down here. I was prepared to prove it up without them, and I did. But the entire time that the trial took place, we were searching for those people. We were monitoring the jail calls. There was contact between this man and his mother constantly about the trial, all throughout the trial while it was done. And so what happens after we get done? We get a PSI that says they couldn't get a hold of the victims. But ironically, before we start this sentencing, they knew about the fact that it had been updated. I didn't. You're giving that.
Objection.
If I may.
That's incorrect too. I did not learn about that until today when Mr. Noble told me.
Thank you, because that's the whole point. Mr. Noble knew. Mr. Noble knew. Mr. Noble did the conduct. Mr. Noble's history is on trial here. Mr. Noble has done everything he can to manipulate the system, including bringing up his childhood friend. The day of accounting is
This
today.
supplemental report, this was information that the officer received 3 days ago. 3 days ago, so it's new to everybody.
All right. One other thing out of his history. He was given a federal sentence, Judge. So he pled true to what's in front of you that doesn't include the federal sentence. Why I want to point that out for a second is it was not a very lengthy sentence, but as Your Honor is familiar with, whenever someone gets a prison sentence in the feds, they get supervised release. Similar to our probation, but it's post, right?
Mhm. Yeah.
He couldn't make those terms either, Judge. That was revoked. So when you weigh it all out and you separate all these things, we're looking to determine, what's the safest thing for Jefferson County? 12 of our citizens disagreed with the arguments that he's made today. They held him responsible without having heard from the victims. They know that the exposure is 25 to life. I am asking that the court sentence him to 40 years.
Okay. You have a chance to rebut. Go ahead.
Your Honor, I would just point out that Mr. Noble is not trying to manipulate the system. He's doing what he has rights to do. He's calling witnesses to testify on his behalf. He admits that his actions that day were wrong, that he overreacted. He understands that. So he's not escaping accountability or trying to say that he's not sorry and remorseful for the way that things occurred. And so I just want the court to be aware that the statements made by Mr. Ham are incorrect. And that's all I have, Your Honor.
Anything else you want to add, sir?
Yes, sir. I'm really sorry about all this. And I know this is very serious. And I didn't tell Philip Jones nothing about coming today. He did it on his own. I didn't. And my mom came to Wednesday in visitation and told me that a man named Riley called. I had no idea what was going on. And my mom said that my stepdad had talked to him. That's how I knew about that situation. But Your Honor, if you send me to prison for a long time like that, I don't know how I'm gonna recover from nothing like that. And I mean, I've been in prison twice, and I tell you, it's just no joke. It's tough. It's hard.
It's supposed to be a
I'm just saying,
punishment.
it's just nobody's down there happy. It's all nothing but a bunch of angry people. And I just think it'll make me way worse if we send me to prison for a long
There's a
time.
way to avoid all of this,
It's just what I feel.
not to commit a crime.
Yes, sir.
That's what we're here on. But it's a similar crime that you were convicted of before. Aggravated assault. I mean, that's the problem is you're supposed to learn, we got to stay away from this. Like it's the bubonic plague.
Yes, sir.
It has its consequences. And then this offense was committed in real inhumane fashion with the gun being, that was just an anger act. I mean, that's meanness. It's not the way you're supposed to treat anyone, much less a close relative. Right?
Yes, sir.
Someone you're supposed to love. What would you do to someone you didn't like? We had 9 prior misdemeanor convictions and 3 prior felony convictions. 2 of those felonies, violent crimes, arson and aggravated assault. And then terroristic threat, harassment, assault, family violence, terroristic threat, assault, family violence. It's 1, 2, 3, 4, 5, 6, 7 other acts of violence. You don't think it's time that you stop committing acts of violence? Anything else? If nothing else, I find as follows, that the defendant has pleaded guilty, has been found guilty beyond a reasonable doubt of this aggravated assault, family violence as alleged in this indictment. Thereafter, being found guilty by a jury verdict, the defendant entered pleas of true voluntarily, knowingly, intelligently to the allegations of prior convictions in paragraphs 2 and 3 of the indictment, where it is alleged the defendant was finally convicted of arson on February 1st, 2001 in the 252nd District Court of Jefferson County, Texas. Thereafter, that became final. The defendant committed the felony of aggravated assault and was finally convicted of that felony in 2010 in this court. And then subsequent to that, he is charged and convicted with the March 17th, 2022 aggravated assault family violence. So the court finds that there is sufficient evidence supporting the finding of guilt beyond a reasonable doubt, and paragraphs 2 and 3 are proven true beyond a reasonable doubt, which puts the defendant in habitual offender category of sentencing. So he's looking at no less than 25 nor more than life, up to life, 99 years or life imprisonment. That's the punishment range the defendant is looking at. If nothing further to add by anyone, the defendant has been found guilty of this offense, is subject to this punishment range of habitual offender status. The defendant is hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 35 years. And the judgment shall reflect that an affirmative finding shall be made that a deadly weapon, namely a handgun, was used in the commission of the offense. You understand what has happened today, sir? Anything else?
No.
That is all.
Thank you.
Here's this. Thank you.
I wonder if he thought
Who do we have?
I wonder if he thought he was going to be able to get away with
Come on
that.
up.
I wonder if he thought he was going to be able to get on probation or get something simple for it. So, all right. So let's go to another old squishy Gardner one. This one's with Judge Ricky. A little bit more lighter. No murders involved in this one.
This is State of Kansas versus Quentin Lawrence Height. It's case number 2025 TR 1215. Quentin Height appears apparently on his own Zoom. Jaron Regier appears on behalf of the state of Kansas and the Butler County Attorney's Office. For Height, court has an information before it which alleges in count 1 the charge of interference with law enforcement, a Class A non-person misdemeanor punishable by up to $2,500 fine and up to 1 year in the county jail or both. In count 2, failure to register a vehicle, an unclassified non-person misdemeanor punishable by up to 30 days in the county jail and up to a $500 fine or both. What are your intentions regarding a plea here this afternoon, Mr. Height?
Good afternoon. I do not intend to plea.
Why is that, Mr. Height?
I have a few clerical things I'd like to clear up. Did you personally read the case filing for BU-2025-CR-000261 in its entirety?
No.
Do you believe that the filing document is true, complete, and correct?
I'm not sure why I'm answering your questions, Mr. Height. We're here on a first appearance on a criminal case.
I am trying to clear up to make sure that the charging documents are true and correct before proceeding.
I see nothing openly defective about the charging document.
Okay,
Well, let's move on. If you don't wish to enter a plea, the court will be entering a plea of not guilty on your behalf, Mr. Height. And we'll be establishing another court date.
Your Honor, that would not be my preference. I would like to have
Well, I don't care if it's your preference or not.
Thank you. I would like to have a probable cause hearing before a plea
You're not
is heard.
entitled to a probable cause hearing. This is a misdemeanor case rather than a felony case, and you're not in custody.
Okay, I have challenges that I would like to raise on the record formally for both the case filing and the field case report from the arresting officer.
Let me ask you, do you believe that you have the financial resources to hire a lawyer to represent you in this case?
I will not be hiring a lawyer. Thank you for asking.
So you're going to represent yourself in this case, is that
I
correct?
will be presenting myself. That is correct, yes.
You do understand that if you can't afford a lawyer, the court will consider appointing you one,
I do comprehend this. Thank you.
but you reject either retained or appointed counsel, and you're going to represent yourself in this case, correct?
I will be
All
presenting
right,
myself.
very well.
Thank you.
There was an appearance bond posted in this case. Apparently, it was a cash bond in the amount of $2,000. It secured the defendant's appearance. The court has approved that bond and will maintain Quentin Height under it pending further proceedings in this case, which I will set.
Before that, I would like to request your lawful determination that this court has jurisdiction over this matter, as I cannot proceed until the field case report and the case filing are both verified complaint.
You know, as funny as it is for him being a sovereign citizen and normally just a general ass, he's not the most annoying person in that room. That Michael McPherson's camera's irritating more than this guy.
And true and correct.
I don't know where you're getting all this. According to the state's charging document, I'll advise you, Mr. Height, that it did take place somewhere in Butler County, Kansas.
Okay, thank you for
The
that.
court does believe it has jurisdiction.
I do have a copy of a field case report and a case filing that I received from the Butler County Attorney's Office as well as the Butler County Sheriff's Office, and I have found inconsistencies in both of the documents that I'm trying to raise here formally with you that I cannot make a plea until they have been resolved.
All right. So I've entered a not guilty plea on your behalf.
I would like to please the court that this would be not on my behalf and under threat and duress, and only under the matter that you have moved on my behalf. I have not entered a plea.
All right.
Additionally, I'd like to let the record show that due to a lack of corpus delicti via verified complaint, jurisdictional defects, and the lack of essential elements to bring a formal complaint and charges against me, I must move for dismissal immediately based on the plaintiff's failure to present all the required elements. That is in regards to the case filing. Judge, I would also like to ask, will you be reviewing the case filing and field case report in their entirety to ensure that my due process rights are not violated before the arraignment hearing begins?
Court's going to assign the case to this division. I'm going to set a court date for Monday, August 25.
And what is the purpose of that court date, may I ask?
For further proceedings in the case, Mr. Height. It'll
Okay.
be your first appearance with following today's date. I'm going to set
Would
the
you
hearing
repeat that again?
time at 3:00 p.m. You may
My
appear
apologies.
by Zoom.
Is there an
3
in-person?
o'clock Monday, August 25 for further proceedings in this case before this court.
Thank you. And may I ask, is there an option for an in-person appearance?
Not for that court appearance.
Okay.
We'll conduct the next appearance by Zoom.
Okay. Is there an opportunity to be in person for any proceedings?
Yes.
Okay. And
But-
which proceedings would those be?
But what we've established today is the next one will be by Zoom. Now,
Okay.
if you don't want to appear remotely, you can come to the Butler County Judicial Center and you can participate from that location. You'll be participating by Zoom, but you can participate from the Judicial Center. To make
Okay.
sure that you have the resources available to you to fully participate in the next hearing. So Monday, August 25, 3 o'clock, he's going to represent himself. And the court
And-
has approved.
All right, this guy was worth looking up. I just looked him up. He's a owner of a real estate company, so he seems to do pretty good with money. Seems to be, pretty well done online. So, anyways, he's gonna give it a go. Let's see how he makes it.
Maintained him under his previously established bond of $2,000 cash.
May I also ask what
Okay,
judge
just a
and what
minute, I'm going to ask the prosecutor. Mr. Regier, is there anything else that we need to address regarding Quentin Height at this time?
Not on this particular matter, Your Honor, although per my duty of candor as an officer of the court, I would tell the court that there does appear to be another case involving this same defendant, where it would appear that an appearance bond has been executed for at the end of next month. I'm not sure, given the court's order today, if the court wishes to address that matter at this time for the purposes of the judicial economy.
No. If he has multiple cases, that's the implication of having multiple cases, that he may have multiple court dates.
Very good.
So let's go ahead and cite for Mr. Height, just in case he doesn't have it written down on his calendar somewhere. What is the next scheduled appearance in this other case?
Your Honor, the state's information is that in Butler County 25 TR 1215, there appears to be a bond, specifically a cash bond in the amount of $1,000 for an appearance date on July 30th, 2025 at 9 a.m.
All right. I'll advise the defendant that he does have a separate appearance requirement in a different case for July 30th at 9 o'clock a.m. I trust that would be in Zoom court with Judge Webster on that date, Mr. Regier?
That would be the state's presumption, Your Honor.
Okay, and then of course you've still got your Zoom appearance requirement in this court on Monday, August 25 at 3 o'clock, Mr. Height. I think that concludes our business on the case at this time.
One further question, please. For this matter, the new hearing that you have just set, who is the judge and the court presiding?
The new one that I just said, you mean in this case that was before the court today?
Correct.
This judge is hearing the case. Okay.
Thank you for clarifying.
And if there's nothing further, the Quentin Height matter will be in recess at this time, and we'll move on to another matter.
Thank you for your time.
All right, Kim was wanting to know what his charges were. I think he stopped too long in a stop sign. I think they said he stayed at the stop sign for an extra 3 seconds, and they can't have that in Kansas, so he'll see Judge Webster for it. All right, let's go to a Judge Webster one. Let's see how she deals with hers.
Now then, let's take up Abel Estrada Jr.
And this one was another old Squishy Gardner clip. I got lazy today. Thank you, old Squishy Gardner.
Mr. Estrada, you'll need to start your audio and your video.
Yeah.
Okay, all right. We are on the record in 2024 TR 617, State of Kansas versus Abel Estrada Jr. Assistant County Attorney Paul E. Dean for the state. The defendant appears in person and pro se. The defendant, let's see, this first appearance back in October of 24. After being dismissed and refiled from municipal court and some failures to appear, then we had a bench trial February 14th, 2025, and the defendant was found guilty and ordered to pay $108 in court costs and the scheduled fine, with the court specifically ordering that if he appeals, an appeal bond set at the amount of cost and fines had to be paid before or at the time of the appeal. We had a peer review, February 28th, 2025. Somehow he was attempting and made some efforts to file the appeal without a bond. He had gone through a couple of attorneys and then ended up representing himself.
Also determine whether he's actually properly docketed it. He's told us that he has. He's told us that he's talked to people in the clerk's office and that it's taken care of. But to date, there is not one piece of paperwork in my file that shows anything from the Court of Appeals, which we would have received electronic notification. Should have received notification of the docketing, should have received notification of any motion that he filed to waive the Court of Appeals to waive the appeal bond. I believe you referenced something of that nature several times. I might be mistaken on that.
That's why I was walking through the history. That's what I'm finding too. When he was here May 9th, 2025, another payer peer review. Let's see. The defendant said he is outside the jurisdiction of this magistrate as he is strictly under the appeal court authority, that he had an appeal court case number. So I could not enforce the order for appeal bond or sentence, basically. So, have you paid? It does, Mr. Estrada, did you pay the fine ordered of $158? The court file says you haven't. Looks like you had 108 court costs and a $50 fine for illegally display of license plate or not display.
Your Honor, I take that back. I think my office has finally found something.
Okay.
It just has not, the paperwork has not hit the file. Looks like transcript's been completed. Oh, well, table of, okay, we did receive, apologize, notice, court docketing notice, appellate court docketing notice. So I think actually at this point in time with that, and that, I don't know why it took so long to get to us, but with that, we can remove this case from this docket and we will take care of it at the Court of Appeals.
Let me see if I find everything. Okay, suspension.
I will have my office, I'm going to ask them to file that of record in this, at the trial court level. That way we have that in there. Judge, you don't see, you can't see that from your end?
Well, let me see. I'm seeing the transcripts.
And we did receive a letter. That's probably an emailed letter, but it is appellate court case number 128,986.
Okay.
So
okay, I did find it. Thank you.
Current jurisdiction at this point in time from the district court.
Okay.
So.
All right. Well, we will just wait and see what the Court of Appeals thinks about your conviction, and I guess they're not going to enforce the order to pay the bond. So if the Court of Appeals decides that piece of paper was sufficient for requirements of tag violations, they'll let you go and it'll be over. But if they find that the conviction should be sustained, that that piece of cardboard that you bought from someone was not a legal tag, then they'll let us know and you'll still owe that money. Now, what I'm wondering, Mr. Dean, I think we might need to look at what appears to be some suspensions on his record for not payment, because if those suspensions for non-payment were filed by our county clerk or our district clerk after the appeal was docketed, those may need to be revisited. If they were done by the Department of Revenue in Topeka at any point in time, I can't overrule or override them. You have any thoughts on that?
Your Honor, I don't know who would have initiated that. Because the case had been on continuance. I mean, the order's quite clear in this case. They would have received that notice of appeal. So I guess we just need to reach out to the clerk's office. If Missy, if you could reach out to them on that, maybe we could find out an answer to that. I would agree there should be no suspensions as a base from this case, that the Court of Appeals has indicated on the letter that I just saw that they considered it properly, timely docketed. The appeal was timely filed, so there should be no suspensions as a result of this matter until we're back here or the Court of Appeals says that it's overturned.
But Mr. Estrada, you might be mindful and check your driver's license and see if the status is suspended, because it could cause you some grief if you're out there driving around with a suspended license, even though we may be able to clarify it eventually and correct if it needs correct it eventually, but it could cause some headache for both you and for this court and the prosecutor having to come back and visit that. So,
and Mr. Estrada, why I've asked the judge's administrative assistant to check with the clerk's office because she's right down the hall from them. I think it would probably also behoove you to contact the Kansas Department of Motor Vehicles and question them about that status. You may find it easier to send them a fax because they're quite difficult to get to get a hold of anybody by phone. In any event, that's all I have, Your Honor.
Okay.
Well, I did get 3 different letters saying that I needed to pay, and I called them and I told them that I'm already in the appellate court, and there's no reason why I should be suspended. Is this gonna cause me any more problems? Is this something that I can call you back so you can confirm to whoever I'm talking to?
You don't need to convince me of anything on that issue. What I'm telling you is I'm agreeing with you, but the state of Kansas, for some reason, has a different opinion, and I think they're wrong. I'm just telling you, you ought to probably reach out and try to speak to them further yourself. Perhaps send them a copy of the appellate court docketing statement, things of that nature. Maybe that'll help clear it up for them.
DMV, okay.
All right, Your Honor. Can we take a short break before we get into our 10 o'clock? I don't have anything further.
All right. We're just gonna hold tight until the appeal is done. I'm not gonna set another case this time, Mr. Estrada. You're excused from today's hearings.
Judge, could we take a break before we get that 10?
I normally enjoy Judge Webster, but that one was horrible. I don't know why I wasted my time on that one. All right, I'm going to jump to another Judge Webster one and see if she can redeem herself on this one. These judges need to understand they need to be more entertaining for us. So let's see where we go here.
Why should I give probation to a gentleman who may have violated the bond? Why should I think he's not going to violate probation in the same fashion? And because a police officer is involved, it makes me think that maybe the bond involves another battery or something.
All right. I think she redeems herself on this one. You seeing Darren Patterson in the room makes me a little more confident. All right, let's see where we go for here.
Okay, Mr. Patterson, who would you like to take up? Oh, wait, is there someone sitting at the jail? Who is that says sergeant that looks like he might have an officer uniform?
Your Honor, it would appear that in this matter, a subpoena was issued for Officer Sarchett in the Brandon Branscombe matter. I'm not sure if the court wishes to take that one up at this time or not.
Yes, yes, we should do that. I'm sorry, officer, to make you wait that long. Everybody's backed up here today trying to get it on the docket. Okay, so this is for Samantha Slater.
Your Honor, the state understands that Ms. Slater is also a subpoenaed witness in this case.
For Branscombe. Okay. We are on the record in 2025 CR 185, State of Kansas versus Brandon Lee Branscombe. Jared Regier for the state, Darren Patterson for the defendant. Please start your audio and video, and please find a spot to sit and not be moving around, sir. Can you hear us, Mr. Branscombe?
Yes, Your Honor.
All right, this is a motion to revoke or modify bond. The defendant is alleged to have had contact with a Danielle Erskine pursuant to Newton PD number 25-1121. And that would be in violation of the defendant's bond. I see we do have subpoenaed witnesses Samantha Slater and Officer Brett Sarchett of Newton Police Department. And I understand that Sarah Recheck, agent of Owens Bail Bonding Company, as well as the defendant and his attorney, were notified of the motion to revoke or modify. Mr. Florio is here for Simpson. Do we have anyone here from Owens for Branscombe? All right, Mr. Regier, do you wish to proceed on the motion?
The state is prepared to proceed, Your Honor. However, this does appear to be a case where the information was originally filed by my colleague, Ms. Norris. I understand there may be certain plea negotiations in this matter, so the state would respectfully inquire of counsel for the defense whether what the status of those are.
I'll accept.
And Judge, I would tell the court that I have discussed with Ms. Norris a way to resolve the case without taking up the motion. Based upon that, I believe my client is going to enter a plea of no contest.
Yes.
So you reached an agreement with the state to set aside the motion, but no one canceled the subpoenas. I suppose that's not all bad in case this no contest plea doesn't work out, but it would have been nice to let the officers know. Okay, so before I let you go, since you've waited this long, folks, if you don't mind just bearing with us a little longer. Mr. Branscombe, I'm told you're going to plead no contest to domestic battery, knowing or recklessly causing bodily harm to a family member or person in a dating relationship in Butler County, Kansas on April 16th of 2025. Do you plead no contest to that, or how do you wish to plead?
That's if I understand correctly, that's the domestic battery, a misdemeanor?
That is a misdemeanor, Class B, alleging that on or about the 16th day of April 2025 in Butler County, Kansas, Brandon Lee Branscombe did knowingly or recklessly cause bodily harm to another person, to wit, Danielle Marie Erkson, a person with whom the offender is involved or has been involved in a dating relationship or a family or household member, as defined by subsection E in violation of KSA 21-5414A1 C1A, domestic battery, Class B person misdemeanor. How do you plead to that?
No contest.
By pleading no contest, you mean you're not admitting that you did this, but you don't want to deny it and take it to trial?
Yes, Your Honor.
Is anyone making you enter this plea today by threats or promises other than your plea agreement?
No, Your Honor.
Do you understand that with this plea, you'll most likely be found guilty?
Yes, Your Honor.
Having waived your right to a trial and not able to appeal that conviction.
Yes, Your Honor.
All right, Mr. Regier, you have a factual basis to support this no contest plea?
Yes, Your Honor. Pursuant to the information, count one alleges that, quote, on or about the 16th day of April, 2025 in Butler County, Kansas, the defendant Brandon Lee Branscombe did knowingly or recklessly cause bodily harm to another person who is identified as the victim in this case, a person with whom the offender is involved or has been involved in a dating relationship, or a family or household member, as defined in subsection E. Were this case proceed to trial, the state's evidence would show the same. Additionally, the affidavit in this case does appear to refer to a past domestic violence disturbance at a location in Whitewater, Kansas. The state's understanding is that is within Butler County boundaries, as well as a reporting physical altercation between the defendant and the victim in this case.
You mentioned an affidavit. Well, the parties stipulate that if this were to go to trial, that affidavit would contain the facts that would be evidence in that trial.
Judge, for purposes of no contest plea, we have no objection to the court using the affidavit.
All right. All right, based on the affidavit, I find there is a factual basis to support the no contest plea, and I do find the defendant guilty. Now, folks, apparently you've worked something out where these folks that have come in from Newton are no longer needed. The Newton officer and Samantha Slater are no longer intended to be called as witnesses. Is that right?
Your Honor, the state's understanding is that upon successfully entering a plea to count one in this case, the state would move in exchange to withdraw the motion.
So are you no longer offering that there was a violation of the no contact order? You're no longer alleging that the defendant violated this court's order by having contact with Danielle Erkson?
Again, Your Honor, the terms of the plea negotiation was that upon successful entering the plea, the state would be moving to withdraw the motion revoking the bond in this case.
Well, you may be withdrawing the motion, but it seems like if we're going to proceed to sentencing, this court needs to know, or would like to know, if the defendant violated its orders, because that could have an effect on any probation that is made.
Judge, I guess I will speak up that is part of the plea negotiations between Ms. Norris and I, that that issue would become moot and not part of the recommendations.
And that is the state's understanding of the negotiated plea agreement in this matter as well, Your Honor.
Well, plea agreement aside, it's troublesome that a man can be accused of domestic violence battery to a Danielle Erkson, and the court can order that he have no contact with her. And I'm supposed to just ignore that and proceed with plea agreement. That's troublesome. Well, let's hear what your plea agreement is, gentlemen. Sentencing recommendations from the state?
Yes, Your Honor. The state's understanding of the plea agreement in this case is that the state would be recommending a 6-month underlying sentence, the maximum sentence allowed by law for a Class B misdemeanor, as well as a 12 months reporting probation with court services, subject to all standard conditions consecutive to any other Butler County cases the defendant may be currently supervised on. The state would further be recommending all applicable costs and fees, that the court make a determination on the issue of attorney's fees, that the court not impose a fine, but that the court require a domestic violence offender assessment, and that the defendant be ordered to comply with all recommendations, that the court order no drugs or alcohol, and that the defendant be ordered to report today to court services.
Mr. Patterson?
Judge, we're asking the court to adopt the recommendations, including that the no contact order can be lifted upon him getting his domestic violence offender assessment and providing that to his probation officer.
And Your Honor, the state understands after further review of the file that that was also contemplated pursuant to the plea agreement in this case, Your Honor.
This Danielle Erskine, she's his sister, is that right?
Ex-wife, Judge.
Ex-wife.
Or maybe common law wife now. They have kids in common.
The kids, okay, they have the kids The kids in
And
call. Okay.
10 years
What?
together. I'm
You have
sorry,
10 years? You and
we
this
have
woman
10
have
years.
10 years? Okay. And 3 kids?
Yes, ma'am.
When was the last time you saw her?
Oh, the day that I was arrested,
And was that is that in
that,
Newton?
yes, Your Honor.
All right. Now, is this Officer Brett Sargent up here on the screen?
Yes, ma'am.
I suspect, though you weren't called by either of the parties, I suspect you have information about this defendant violating the court's order. Am I suspecting correctly?
Yes.
All right. I'm not going to put you under oath, but tell me, just initially, informally, what the involvement is.
Judge, I guess I'd have to object because if we're gonna get into a full-blown hearing, I mean, that's one thing, but not to have the ability to dispute it.
Fine. All right, fine. Raise your right hand. You solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Patterson, I don't know what you guys have going on that you're trying to get around the courts knowing that he's been out violating court orders.
And Judge, that's disputed. I'm gonna tell the court that's disputed. My client would suggest that he's not the one who had invited this contact, that it was not him, so it's disputed, but that's why we've entered into plea negotiations to avoid the confrontation of a hearing.
Mr. Regier, what do you have to say about not wanting the court to know that there may have been a violation of a domestic battery bond or order that could affect, and why it's important now is it could affect his success on probation? Why should I give probation to a gentleman who may have violated the bond? Why should I think he's not going to violate probation in the same fashion? And because a police officer is involved, it makes me think that maybe the bond involves another battery or something. And that's important. So, Mr. Regier, what do you have to say for the state on this?
Your Honor, all I can tell the court is that the state did anticipate proceeding to a hearing today. However, the state is eager to reach a resolution in this case, and all I am aware of is the terms of the plea deal as negotiated between my colleague and counsel for the defense.
Ms. Slater, how are you involved in all of this? Are you an officer? Are you a family member?
No, I witnessed a verbal-ish altercation at the end of April in Newton.
All right. Well, I am going to tell you both, I'm not going to sentence him to probation until I know what's really going on here.
Judge, short of getting into a long trial, which is basically what we're talking about, I can tell the court my client was not arrested for a domestic violence event that day. Miss Erskine was, I understand, but my client was not.
Well, why can't Officer Sargent? Why do you have an objection to him saying that if that's all it was? I think there's more here than what you guys want me to know. And
I'm trying to avoid a long hearing, Judge, and get
Well,
the
that's
docket done. That's
fine.
exactly what that's a
Well,
purpose.
I'm all about avoiding long hearings that are unnecessary, but I am not going to shortchange somebody's physical well-being and put him on a probation if they've gone out and had another altercation while on bond when they were ordered not to have contact. I'm just not going to do that. So you guys can either have a hearing or I'll just order a sentence without probation. I'm not going to take a chance that somebody is going to get hurt again. And I'm not going to just ignore evidence that's right in my face. So you tell me, Mr. Regier, you're wanting me to do just that? You're wanting me to just ignore that he's apparently apparently gotten into another domestic altercation with her when I ordered no contact? I'm supposed to ignore that? As officers of the court, can you genuinely recommend I do that?
Your Honor, may I request a brief 2-minute recess?
That would be fine.
Thank you.
Mr. Regier, if you're available, I'd like to reconvene. Mr. Regier, we are back on the record in 25 CR 185, State of Kansas versus Brandon Lee Branscombe, all parties as before. All right, folks, I set the bond as my responsibility. I set bonds. As my responsibility, I impose sentences. But before I proceed any further, I have to know what's really going on here. And both counsel have indicated that I shouldn't hear from this Officer Sergeant. But Officer Sergeant, do you have any information that this defendant violated the bond in this case, wherein I ordered that he have no contact with Daniel Erskine?
I do.
And what information do you have?
On April 24th of this year, we responded to a disturbance between a male and a female. Both the male and the female were located. I spoke with the witness who is here with us today, and she informed me that she watched a man driving a white SUV pull up into the alley near where she was parked. She saw the male exit the vehicle and begin screaming at a woman who was seated in the passenger seat. Upon locating both individuals, they were both identified, and they actually admitted that they had a no contact order in Butler County for a recent domestic violence arrest.
All right.
I also have another issue at hand. Last week, I reached out to the Butler County Sheriff's Office in hopes to get in contact with them to verify whether or not the bond conditions were still
I'm
in
going to
place.
object as hearsay, Judge, unless we have somebody from Butler County here.
I want to hear it. Go ahead.
I did that because I forwarded this case to the Butler County Sheriff's Office based on the information that the defendant had informed me of, that he had bond conditions. Last week, they were in contact again. We arrested.
Hang on. Who was back in contact again? The man and the woman?
Yes.
Okay.
So what he informed you earlier, that the last contact he had with her was the date he was arrested, and was untruthful.
Okay. All right. So the man and the woman in the truck, do you know who they were?
It was Brandon Branscombe and Danielle Erskine.
Okay. I didn't totally follow the Butler County thing. You contacted Butler County and told them what you had in Newton?
I tried to. I asked our dispatch to send a teletype, basically an email to the Butler County Sheriff's Office, to have one of their deputies reach out to me so I could verify whether or not the bond conditions were still in place.
And the result?
They did not reach back out to me. They did not call me.
Okay. All right. Okay. Ms. Slater, please raise your right hand. Solemnly swear the information and testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right. Now, what can you tell me about anything that has to do with this Butler County case involving the defendant, Mr. Branscombe, and the victim? She's now determined to be the victim, Daniel Erskine. What can you tell me, if anything?
Sure. The only thing I can tell you is what I saw. I believe it was April 24th. I was in Newton for a work-related reason, but was sitting in a parking lot at the Dillons, and in front of me, a white SUV went into the alleyway that was in front of me, and I saw a gentleman exit the driver's side of the vehicle, shut the door, seemed flustered. I could not hear anything that was being said at all. I didn't have my windows rolled down or anything. I was just going off of visual. I could visually see that he was upset. He was yelling at the vehicle. And then after a little bit of time, I don't know exactly how much, he went to the passenger side. And then the passenger side door opened. He did not open it, but it did open. A woman got out. And then they were having a verbal altercation. They walked behind the vehicle, and then I saw her put her hand on his arm, kind of like a, hold on a second, come back kind of thing. And, he pulled his arm away, and he was still yelling at her. I couldn't really tell what her demeanor was or her reactions or anything. She did have her hands up a little bit, kind of like, whoa, hold on a second kind of thing. And then he continued to walk. He did pass the car. She did get into the driver's vehicle, or the driver's side of the vehicle. They were kind of following each other down the alleyway. There wasn't a whole lot going on at that point. I could still see that he was, agitated. He was still yelling at the vehicle. They did stop a couple times. I never saw her exit the vehicle again after she had got out of the passenger side. And then they had come to a street. I don't know Newton super well, but they did come to a street. The back hatch of the vehicle opened, and then it closed. I didn't see if anything was taken out or anything like that. And then they did continue to drive down the street. And then when they passed, I believe it's Main Street in Newton, I couldn't really see them after that. I saw her pull into the Little Caesars parking lot, and then I was kind of done with it at that point. I couldn't see anything anymore after that.
Did you report that at any time to law enforcement?
Yes, I called 911 just shortly after she had put her hand on his arm.
All right. Thank you.
Yep.
Officer Sargent, you're the one then that took the report and worked it?
There were, I believe, 3 of us working that specific case.
Have criminal charges been filed against either party, Branscombe or Kirkson? Do you know?
Yes, both of them went to jail that day.
Okay, and do you know if the prosecutor filed anything formally yet?
That I'm not sure.
Okay, all right. Okay, well, thank you both very much.
Judge,
Now,
I have a question for the officer.
all right, go ahead, please.
Officer, you said both of them went to jail that day. What were the charges against each of them that they were arrested on?
I believe Brandon was for driving on a suspended license, and the Danielle was for domestic battery.
Okay. Mr. Branscombe was not charged with domestic violence or arrested for domestic violence at that time. Is that correct?
Correct.
That's all I wanted to clear up, Judge.
And let me follow up. Okay, driving while suspended against Brandon, and what did you say against Danielle?
Was for domestic battery.
Okay, all right. Mr. Regier, you have any questions of either of these two?
No, Your Honor.
Did you have any for Miss Slater, Mr. Patterson? Okay. Well, folks, I am going to take this all under advisement. Mr. Branscombe, your attorney may not want you to talk right now. I don't know. He wants to talk, Mr. Patterson. Do you want to let him?
I will talk with Mr. Branscombe later, Judge.
All right. I am going to set over the sentencing on this. Now, the problem is I'll set the sentencing over 1 week. I know I'm gonna squeeze another one on you. Can we put that at 1:30? 1:30 by chance, Jen, on Wednesday? No, that can't do that either. Never mind. Let's put it 9 a.m. Monday, and the defendant must be present at the Butler County Courthouse unless his bond is revoked. And at this time, I'm going to revoke his bond.
And Your Honor, Your Honor, as indicated on the record, the state has withdrawn its motion pursuant to.
I understand, and on my own motion. Mr. Branscombe, where are you at this moment?
I am waiting to enter into a inpatient facility. I've got my assessment and everything. My bed's
I didn't
waiting.
ask you what you were doing. I said, where are you? What town are you in?
I'm in Wichita, ma'am. Your Honor.
Wichita? All right. Are you in a residence? Are you in a treatment facility?
I am at a residence and I'm waiting for the court to be done with so I can go into my inpatient. They told me if you guys needed to speak with them on the court's behalf, need to speak with them to verify that, for me to give you their number and they would verify that.
What are you going into treatment for?
For drugs and alcohol, Your Honor, I have an addiction problem and I mean, I need to get it taken care of.
So you couldn't even report to probation. You're not even ready to start reporting to probation. You're going into treatment.
Yes, I mean, yes, Your Honor, I feel that getting myself for.
How about batter's intervention? Have you done an evaluation for that yet?
No, ma'am, I started mental health and med management through Prairie View and Newton. And I've been working with CCRT. I don't know if you're familiar with them, but they're out of Newton, Harvey County. And they have, I'm sorry, they also have the BIP program there at their location.
Okay, so you violate bond. You work out this nifty plea agreement with the prosecutor that you don't have to face any consequences for not only violating bond, but going out and getting into a confrontation with the victim. And then instead of reporting to probation, you're telling me, or going to jail, as I could order you, you're telling me, well, I went out and I got myself into an alcohol and drug treatment program. Although the issue in front of this court is domestic violence, it probably is aggravated by drugs and alcohol. Counsel, I feel like you've brought me an impossible situation unless I just order the police to go out, pick him up, put him in jail, and let him serve 6 months. I feel like I have been manipulated to the utmost in this case, and that's not like either one of you two to do that to me.
And Judge, I guess I take offense to the word manipulation. These are standard plea negotiations that I've entered into with the state. So yes, have we entered into a plea negotiation that was to leave out information from the court? Yeah, that's just standard plea negotiations, and that the court has on its own retrieve that information. Well, this is Your Honor, this is your court. I can't really stop the court from doing that since the witnesses are right here. But I think it is a plea negotiation that was warranted and well thought out, and one that we presented to the court.
Well, and I appreciate your offense, Mr. Patterson, but here's why I see it as manipulation. You weren't going to tell me that he was having contact with this victim of abuse. You weren't going to tell me that he was screaming and yelling at her to the point that a citizen called law enforcement and law enforcement came. You weren't going to tell me that he was seen driving while his license was suspended, which is a violation of the law. Bond says don't violate the law. Bond says don't have contact with this woman. Then when I get to sentencing, you've got him signed up to go into an alcohol and drug treatment program that nobody told me about, but it would circumvent reporting to treatment. And what about that statute that says he has a mandatory 48 hours and a mandatory $200 fine, which I can waive if he does the BIP intervention? But he's not set to go into BIP right away. He's set to go into alcohol and drugs. That to me looks like manipulation so that he doesn't have to serve his sentence, that he doesn't have to have any consequence for violating bond, manipulation that he doesn't have to have any consequence for what happened in violation of the law while he was on bond. I mean, driving was suspended. That's a B misdemeanor, a crime. And I'm not supposed to know about any of this. Let's keep the judge from knowing this. Mr. Patterson, that to me looks like manipulation. Maybe it's not. Maybe you don't see it as that. And I respect you as an attorney, and I have for many years, and I respect Mr. Regier as an attorney. And I have for not as many years because he hadn't been at this as long. But this is highly troubling to me that I'm seeing this. And if this is standard, and I haven't seen it before, and I'm being duped by it, that's alarming. Because judges are supposed to know what they're dealing with when they make a sentence. And how's Mr. Branscombe going to deal with this? Again, this is outside of my jurisdiction, but at the same time, what he does in other jurisdictions should affect what he does in this court on probation or as such. But if he's facing driving while suspended charges, but he can't go because he's in treatment.
I don't know that he is, Judge. I haven't seen any charges filed in the city of Newton.
Fair enough, fair enough. And I know that if they need alcohol and drug treatment, that's a very big, important priority. Unless it's designed as manipulation to skirt consequences. Was there even an evaluation, or did I understand him to say he just went and signed up for it?
Judge, I can tell the court this was the treatment program was not part of this case or part of the negotiations. That is something he's doing on his own. This is the first I've heard of it. The batter's intervention program, on the other hand, is something that was part of the plea negotiations.
Mr. Branscombe.
Yes, Your Honor. I just want to say that I did get a evaluation. Actually, I got several of them over this last about week and a half to try to find the earliest opening bed that I could so I can get into treatment sooner than later. And the one that I found was supposed to be today at 9 o'clock in the morning. I had court at 9, so they extended it till 1. But I have another, they said that it would be okay if I came in tomorrow. If it doesn't work, they told me to give the judge their contact info and that she can contact and, talk to you and tell you about, how I came about getting there and everything else. I'm not trying to manipulate you, Your Honor.
Mr. Branscombe, this allegedly occurred April 16th. Well, this did occur because we found you guilty. April 16th, 2025. What motivated you between then and today, June 9th, 2025, to go out and get this evaluation?
Well, the loss of my children that were taken from me and my wife not being able to have contact with each other.
But you have been having contact.
I have. I'm not going to completely lie to you, Your Honor, but it hasn't been like it was. Like we're a family. We live together. We're with each other every day. We're a family. We have a business together, and it's gone from all of that and all of a sudden in one waking moment, my children were taken away. I wasn't allowed to be told where they were. My wife I was told I couldn't have contact with her. So there goes my work because I don't have a valid license. She was the one who drove us, and she was my helping hand in our business. I mean, we have a LLC. We've been open for 3 years, and it's just all of these things were just all at one time. And I just came to the realization that, when we were clean for 7 months just recently, we got off the drugs and we were clean for 7 months. We didn't argue one time, Your Honor, like not one fight. I mean, nothing. And it was awesome. It was amazing. And then we relapsed, and things got worse and worse and worse, and I recognize what it is, and I know that I can't get my family back without me getting myself clean. And it's been on my heart and my mind that I've been thinking about it over the last month and a half, 2 months, and it's time. I want my kids back. I want my family back.
Did you make this appointment after you had contact in Newton with law enforcement?
Yes, Your Honor.
So it wasn't the domestic violence in this case that was the final trigger to make him do the appointment. It was this second contact?
Yes, it's just that it wasn't
All
the
right.
domestic.
It wasn't the domestic. Go ahead.
It wasn't the domestic per se. It was just me coming to the realization my family's been torn apart and being held away from me, and it's all due to my usage and being an addict. And I wanted to get it fixed and then get it right. I don't want to lose my wife and my kids.
Well, you're saying all the right things.
I mean,
Okay. When's your next available bed?
today
What time?
it was at 9 o'clock, but they said they can push me out until 1 o'clock
1
for them
o'clock.
today. Yes, ma'am. And if I can't get in there by 1 o'clock, that they want to be able to get me in through the rest of the day. That tomorrow morning to be there at 8.
This is alcohol and drug treatment. What was the facility?
It's Cherry Creek.
Cherry Creek. Okay. And it's in Newton?
No, this is in Wichita.
And it is inpatient for how long?
I believe it's a 30-day program.
You don't know?
I haven't got all the fine details. I mean, they sent me the
were gonna-
pamphlet.
You were
I'm
going to
sorry.
go check into this facility without even asking them how long the program was?
I need it, ma'am. I mean, if it's 30 days, 60 days, it really don't mean a lot of difference to me as long as I'm getting what I need to and getting some clean time back under my belt and getting back out here for my family.
Well, I cannot tell you how many times I have seen someone who gets into your position use treatment as a hiding, as a manipulation, as a way to avoid consequences. Whether you're doing that or not, I don't know. You sound, like I said, you're saying all the right sounds or words. You've got the right inflections. I am going to withhold your sentencing until you complete your treatment, but it better be inpatient.
Yes, Your Honor.
And you contact the attorney as soon as you get close to your out date.
Yes, Your Honor.
And I'm going to get you right back in here as soon as possible for your
Yes, Your Honor.
sentencing.
Yes, Your Honor. Thank you.
Is everyone clear on that? We'll
And Judge,
continue.
I guess what I'd ask him to do is when he goes to the treatment facility, that he have them send me a report stating he's admitted and what his out date will be. That way we know a little bit sooner than just when he's released.
Yes, do that because Mr. Patterson, and if you'll get that to me, I'm going to set the hearing in relation to when the out date is set to be so that I don't just drop the ball waiting for him to contact us because we know that that would not be a wise decision.
Yes, Judge.
But but in the meantime, I'm still going to set a date, just a control date, Mr. Patterson, but I want to change it. What do we have, Jen, about 30 days out?
1 moment, Your Honor, I'll look.
Okay. And it could be that if it's a 30-day treatment program, we may end up getting lucky and setting it now, but. And why isn't the victim here, Mr. Regier? Did she have notice of this hearing?
1 moment, Your Honor.
I'm going to, Officer Slochet, Ms. Slater, you are welcome to stay to the outcome, or you're welcome to go. We've used so much of your time this morning. I want to thank you for being here. I want to apologize that you've had to wait so long. But I'm going to leave it up to you if you want to stay or go.
Thank you.
You're welcome. Thank you.
Your Honor, the state's information is that there has been contact between the victim and my office as recently as within the last 2 to 3 weeks.
Well, make sure she's given notice of this next hearing. It would be helpful to hear from her. Okay, Jen, did you find a date about 30 days out?
1 moment. We have some room on July 7th or July 21st.
Let's see. Let's go with July 7. That's closer to the 30-day mark. July 7, 9 a.m. This matter is continued for sentencing unless, Mr. Patterson, you find out something closer. I don't want him out before I see him again. I don't want him, but you are still on bond. You are not to have any contact with her, Mr. Branscombe. You are not to violate any laws. You're muted, sir.
Yes, Your Honor, I understand.
All right. Anything further from anyone?
No, Your Honor.
Not from the state, Your Honor.
Thank you. Get to treatment. You better be there at 1 o'clock or it's a violation of your bond.
Yes, ma'am.
All right.
I don't know if she believed him or if she's just calling his bluff. I think it. I deal with stuff like that at my work to where it really doesn't matter if they're lying to me. It is what it is. So just let them do what they're going to do. So she may just be calling his bluff. She may be so fed up with it all. She's just ready to get it over with. Either way, I feel that way about the live. I'm going to go ahead and get it over with. We'll see you guys tomorrow morning with I guess the court hopping. We'll see you then.
No, I'm totally fine. Like, love it, love it, love it. Can I ask why?